Hi, welcome to my court coach. I'm Jaylyn and I'm going to be your instructor as we talk about the request for order. So what is a request for order? It's a motion that is used or a document that is used to request orders. So orders because the other party is just not in agreement with you about child custody and visitation. They're not in agreement with you on child support, spouse support, contributing to your attorney's fees, or any other request that you can possibly think of that you want the court to make an order or to decide on because the other party is not in agreement. You're going to file a request for order form. Sometimes parties just file in their responsive declaration to a request for order, or they just show up to court on another party's request for order asking for something. And this is highly inappropriate. You're going to get denied. So anytime you are requesting something, you have to actually file for something. So even if there's a hearing on calendar, because the other party is bringing you to court on something, and then you show up to court and then you have additional requests that are not related to the request asked by the other party, the court's going to deny it. So when I say no exceptions, you must file the FL 300 whenever you want the court to order something in your favor. Now, if there are forms out there that are related to your specific request that's not on your FL 300, you can't find what you're looking for on the FL 300, and I'll show that to you really quick. Child custody, visitation, spouse support, child support, domestic violence order, attorney's fees, property control, and then there is the other. If you need a request that is not related to these 7 issues and you cannot find a form relating to that specific request, then you're going to write that here. And so an example of this, there is not a form that I would allow you to request selling the home, for example. You would have to use this form. So you would actually have to look at your local rules to see if there is a judicial council form that has been formed and for your benefit and for your usage. All right. So the request for order, it has to set forth facts sufficient to notify the other party of the moving party's contentions in support of the relief requested. So what does that mean? That means you have to tell the other party what it is that you're requesting and what is supporting what it is that you're requesting. You can't just say, oh, I just want sole legal custody. And when the court asks you why, it's because I'm the father. That's why. That's not going to support you as to why you need sole legal custody. You need to actually show and explain to the court why it is that you're requesting what you're requesting. If you're going to file a request for order form and it has any property or income information or financial information or any financial requests or property requests, you need to have this income and expense declaration form. And it has to be current. And it has to include documents that demonstrates the party's income. So like paycheck stubs, tax returns, Schedule E's, profit and loss statements, literally anything that is going to demonstrate your income. Now, when seeking child support orders, a party must also complete an income expense declaration. Now you see in section 2 and 3, it says that this income expense declaration has to be filed with your request for order form. In reality, you don't have to have those filed with your request for order form because all documentation that needs to be filed for or in support of your request for order hearing, that has to be done 16 court days before your hearing. So if you file it 16 court days before your request for order hearing, then you're good. If you file it much later than that or even a day later than that, then that is not good. and the court might admonish you for that, and especially they might admonish you for not following the California rules of court, and that is not going to bode well for you, especially if you're the moving party for any relief request for child support. The moving party must file the documents with the court clerk to obtain a court date and then have a filed copy served on all parties in the case within the timeline required by law. So earlier we were talking about 16 court days, and that is for personal service on the other party. So if you've already filed, let's say, your income expense declaration with your request for order, you must also serve the other party with that documentation. Now, if you do have a judgment in your case or a final order made in your case, and now you're filing to modify those orders, then typically you would have to deliver those documents in person to the other party. However, since you are requesting custody visitation and support, that means you more likely than not have contact with the other party. And so serving them personally might not necessarily be the best way to go. And therefore the court's allowing you to do it by mail because you probably know the address of the other party because you do the exchanges at their house. So the court does lay out some exceptions as to how to get around this personal service after a permanent order has been made. And the declaration regarding address verification has those exceptions listed. And then the following blank forms must be served with a request for order. So the responsive declaration, which is the FL 320, has to be blank, and then a blank income expense declaration. Then we will talk about the responsive declaration to a request for order and procedure in a separate video, but we just wanted to focus on what is a request for order, the purpose behind a request for order, and then the procedures in which we need to serve the request for order. So you would review California Rules of Court 5.92, and this is the FL 300 form. And we hope that you have found this helpful, and best of luck.